presumption, a particular rule of law that may be inferred from the existence of a given set of facts, and that is conclusive absent contrary evidence. It's conclusive absent contrary evidence. That's the title. That is what I'm talking about today, rebuttable presumptions. Okay, most of us are already familiar with this, but I think it's necessary for me to do a video about it. Because that's actually, we already know that this is what they do in court. They operate based on a lot of presumptions, and in most cases we fail to rebut the presumptions in court cases. Majority of the time we do that. Say contrary to evidence, and absent contrary evidence. Basically, they roll with the rebuttable presumptions because there is no evidence to the contrary of what they're presuming. So if you have no evidence on the record during any proceeding, they're going to rule based on the presumption simply because you fail to present any evidence to rebut their presumption. Okay. I'm gonna, y'all know I'm in Georgia, so I always use the Georgia codes, the Georgia laws, codes, whatever you want to call them. You know, basically showing you how to play the game. These are like the Monopoly instructions. If you're playing Monopoly and you have the dog, the cat, the little shoe, the iron, the car, whatever it is that you're using to go around that board, that is the straw man. That is the entity that you're using to conduct business, okay? To play the game, okay? That's the entity you're using. These codes are the instructions that came with the Monopoly game, okay? I'm trying to help y'all to understand this, why it's so important to read the state codes in wherever in the state that you're conducting business, quote unquote, in. Even if it's a court case, because court cases say all crimes are commercial. So everything they're doing in court has everything to do with money. Okay, it's finances. It's a financial transaction, so to speak. So that's what they're doing. They're conducting business in court. So these are the rules of the game that shows you how to play the game. So you got to read the codes to show you how to play the game. Okay, in certain presumptions of law, such as presumption of innocence. In some cases, presumption of guilt, the presumption of continuance of life for 7 years, the presumption of a mental state once proved to exist, and all similar presumptions may be rebutted by proof. Y'all know this is what I've been talking about for the last few weeks, actually. Actually, I started talking about this in 2020, right there at the beginning of the pandemic, but I got off of YouTube because that's the same year they shut down my old channel, which is in January 2020. But I made a video about the presumption of life and presumption of death, all that stuff. I did that like in February, the following month. I just didn't stay on it. I got off of this for a while, but anyway, I'm back in it, and y'all see I'm dropping videos every week now. Okay, as you see, this is actually let's see. And letting you know that all these presumptions right here, presumption of innocence, presumption of guilt, presumption of continuance life after 7 years, of the presumption of continuance of life after hold on a second, continuance of life for 7 years. It didn't say after 7 years, it says for 7 years. There's no, they're only presuming you to be alive for 7 years. Notice how they put a limitation on it. They didn't say after 7 years. They don't presume that you're dead after 7 years, that you're alive after 7 years. They're presuming that you're continuous of life for 7 years. I just noticed that. That's why I thought I had to put this in there, because after 7 years, according to the Cesta KV Act of 1666, they presume you're dead after 7 years. That's the general number based on the act itself. In some states, they don't go 7 years. They go 5 years. Georgia is 4 years, as I showed y'all on previous videos. It's 4 years in Georgia. But Based on the Sestakv Act, is 7 years. Then it's a presumption of mental state once proven to exist. You know, bottom line is you need to be presenting proof. If there's anything that's being claimed against, I'm gonna say you. When I say you, I'm not talking about you, the living man or woman. I'm talking about your entity. Okay, the straw man, your monopoly piece. Okay, your monopoly piece. They're presuming something about your monopoly piece, about you. And if it's not true, and it can be rebutted based on some evidence, some proof, then you need to be presenting it. If you don't, they're gonna flow with the lie. Okay, they're gonna flow with it. Let's see. I don't need to use none of that. I ain't gonna use that in this video anyway. Presumption of, no, I don't want to go to that yet. I'll go to that later. Okay, let's go right here. Just like third-party debt collectors, this is what they do in business too. Presumption from failure to answer a business letter. In the ordinary course of business, when good faith requires an answer, it is the duty of the party receiving a letter. Even when you're getting served a court document, receiving a letter, it's a business move. They're trying to conduct business with you. From another to answer within a reasonable time. Otherwise, the party shall presume to admit the propriety of the act mentioned in the letter of the party's correspondent, and to adopt them. That means you admit it just simply because you received the document and you didn't respond. You chose not to respond to it. I've told y'all. Remember, I've mentioned before. I never tell people, you know, not to get served, you know, because they don't want to receive the document, you know. They're gonna, because if you try not to get served, say for child support purposes, you try not to get served, you know, they're gonna they'll put it in the newspaper. It's called service by publication. Let me jump on that real quick. Service by publication, so y'all get what I'm talking about. My Wi-Fi moving kind of slow for the last damn 24 hours since yesterday. I don't know why it's doing that. I might have to reset my modem or something. I'm gonna call Spectrum because they on some bullshit for the past day or two. But it's opening up. Service by publication is a substitute delivery of litigation documents. See, it's a substitute to give the opposing litigant notice of the suit against them by publishing the documents in the advertisement or in a newspaper of general circulation. Okay, it's service by publication. So don't run from people trying to serve you something. They're trying to do business with you and you're trying to run from it. You know, you're gonna get served. They're gonna put it in the newspaper and you don't know it's in the newspaper. Most of y'all don't read the newspaper anyway. Hell, most of y'all don't read shit. That's a lot of y'all don't read that anyway. Matter of fact, I'm gonna read this part right here. It says Rule 4. Let me read this here. This looks like it might be something I might want to include in here. Come on, man. This thing is moving so damn slow. Let's see. Rule 4J1, service by publication and the due diligence requirement. What's email got to do with service of process? I don't want to jump into that one. I don't want to jump in. I want to stay on the course for the sake of time. I want to find something. Let's see. Service by publication, summons. Yeah, we rules. No, that's another. I don't want to read that one. God damn it, get back on there. I'm looking for a certain. Get your ass back on there. Bear with me, y'all. I do things like that. I like to use wordplay in my search engine a lot because it kind of helps me with finding certain stuff that I'm looking for. This was so what I read y'all the first time was actually that's actually what I was looking for. No, this is what I was looking for right here. Cornell Law. You know we use that all the time. Cornell Law, which is right there. That's what I was looking for when I was scrolling. Come on, open up, baby. So you get what I'm talking about. So they will definitely put it in the newspaper, and you never know that it's in the newspaper. So you'll know exactly what the document says if you just receive it and just answer to it. It doesn't mean that you're locked in because you received it. It just means you were served. You can't deny, you can't complain that they didn't do due process if you running and trying to keep from getting served, and then when they put it in the newspaper, you claim they didn't do. They denied me due process. You was running. If you running there, they put it in the newspaper, you got served. It's a substitute it's a substitute delivery. That's what it says right here. A substitute delivery, a substitute service. When filing any document with the court, the party filing papers must serve the other party with a copy of it. Serving the document means making sure that the person whose rights are being litigated, fought over, receives a copy of the document. The purpose of service is to make sure that anyone whose rights are at stake has notice of what's going on in court regarding those rights. Keeping all parties informed of events affecting their rights is a critical aspect of due process. See, they're trying to make sure that you are aware of what they're trying to do. And if you're trying to run from getting served, then that's another reason they put it in the newspaper. They have to give you due process. That's why they'll put it in the newspaper. So a lot of y'all that have been running because they serving at your mama house and you don't live at your mama house, and that's the only way and you're aware that them folks, your mama done told you that them folk done sent something to you, or whatever she said, you don't stay there. Some kind of way you found out, but you just kind of run it anyway because you're scared to get quote unquote put on child support. So you'll run. You'll just kind of avoid getting served. Before you know it, they get permission from the courts to put it in the newspaper. So you still getting served. Okay, let's see. I guess I might as well read this little part, and then I'm gonna go back to my original topic. Service can be accomplished either by personal service or substituted service. Substituted service. Personal service is referred to a method of service whereby the party physically hands the papers to the other party. Once the physical exchange has taken place, the other party has been served. This method of service is also called in-hand service. See personal service for more information. The second method, substituted service, can replace personal service in substitution where personal service is not required, such as a plaintiff serves a summons in in-rem or quasi-in-rem action. For example, in some states like California, plaintiffs can substitute personal service of process by leaving a copy of the summons at the person's dwelling house, usually a place of abode, or usually a place of business. See, if they serve you at your job, they'll give it to the HR department and give it to your ass, and you consider served. But anyway, I wanted just pretty much want to kind of bring that service of publication, kind of bring that around so you understand why they still use that. You shouldn't be running. Go ahead and get served so you can actually respond to it. Cause they may have some rebuttable presumptions in the paperwork, and most likely they will, cause they're serving all caps name for one, and they serving a living man or woman in substitute for the person who's actually who they're talking about in the paperwork. But it's just your job to respond and rebut the presumption and all that good stuff. If you want to relate what we talked about for the last few weeks, like the presumption of death, that's the first presumption right there. You know that you're dead. They know your ass ain't dead because they know how to find you. But they're flowing with the presumption because you don't know that. They're going with the assumption that you don't know that presumption. And you don't know to rebut that presumption. You're thinking that name is you. And a lot of other factors take place in that too, especially when it comes to auto loans and different stuff like that, pretending as if you owe them something when actually they got money from your minor account and they funded whatever it is you applied for and pretended like you owe them something, as if they gave you money out from their own pocket when they didn't. That's another topic for another video. But this is what we want to stay right here on service of publication for a second. Let's see. Let me read this little part. This is part of what I'm talking about. Service by publication may be used in an attempt to notify a defendant who is intentionally absent, in hiding, or an unknown or at an unknown address. See, y'all trying to run, they're gonna put it in the newspaper. I just said that. You're intentionally absent. You're trying your best to avoid being served. You're in hiding, you're running. Yeah, I've been telling y'all this for years. So don't run from getting served, because they will put that shit in the newspaper and you don't know they put it in the newspaper. Courts are very hesitant to allow service by publication, and will often require a reasonable basis to believe that the defendant could not be served with more conventional methods. But they will, a lot of times they'll do the shit anyway. They ain't gonna just restrict from doing it. They do the shit real quick. So let's see. Service by publication may also be accepted in a divorce action to serve a spouse who has disappeared without leaving a forwarding address, or to give notice to people who might have a quiet title action against the owner of real property. See, so just understand, this is never run from getting served. Okay. Now back to what we were talking about. Do I want to go to that part yet? Not yet. Presumptions of law. I think that's where I want to be at right now. Yeah, this is where I was at first. Okay, so back to the business letter. So you have to, let's see, otherwise the party shall be presumed to admit the propriety of acts mentioned in the letter of the party's correspondent, and to adopt them. So if you get served something like this, child support, third-party debt collector, student loans, or whatever it is that somebody's saying you did, hell, or somebody saying you attacked them, and it's some kind of what they call application hearing. Let's say a warrant application hearing, where you got to come before a judge and explain what happened, because somebody said you did something to them and they're trying to apply for a warrant. There's something called a warrant application hearing. And if you run from getting served, then you acquiescence. It's like you agree in that whatever it is that they said about you, you agree. So you admit the propriety of the acts mentioned in the letter of the party's correspondent, and to adopt them. That means you agree to it. You're going right along with it. You have embraced the fact that's what they said, that is true. That's how a lot of third-party debt collectors get default judgments against you, because you won't respond to what they said to you in private. It's just like the Bible says in Scripture. It says, agree with your adversary quickly. That's also Scripture as well. People don't know that. I wish this damn thing wasn't so slow. But I'm working with it. Got a little patience with it. Where's Bible Hub? BibleHub.com. See, this is because a lot of people don't understand that these scriptures they're talking about. There's a lot of wisdom in the scriptures. Okay, right here. This is the New International Version. Settle matters quickly with your adversary who is taking you to court. Do it while you are still together on the way. That's before you get there. Okay, or your adversary may hand you over to the judge, and the judge may hand you over to the officer, and you may be thrown into prison. Of course, we know most of the time it's not always prison, but it's just kind of using you get it. You always say when you're on your way to court with the adversary, settle your differences quickly. Otherwise, the accuser, that's the plaintiff, may hand you over to the judge. You will be handed over to an officer. This is why I didn't throw my Bible away, y'all, because I know it's a lot of wisdom up in there. It's not what the church teach, but you got to study for yourself to find out what it is the Bible really teaches. And you'll be thrown into prison. Come to terms quickly with your accuser. That's the plaintiff. While you're going with him to court. See, this before you get there. This is how accident attorneys do. They gather all the information When you have a car accident, they have you to go to chiropractors and all the different stuff, and psychiatrists, and see if you've been emotionally damaged some type of way, physically damaged, your x-rays, see if you broke anything, any fractures. We get all the evidence, all the medical reports, all the affidavits, everything to gather to build your case against the opposing party who injured you. And then what they do is come up with a sum of number privately with a copy of the evidence, and they send it to the opposing party. And they accuse them of what they did, and they look, this is what we're gonna settle. If we go to court, this is, there's another law. I ain't gonna show that now because I have to look for it in my computer dragging. But if you go to court, if y'all have to go to court, they'll be able to sue them for 3 times the amount of what you tried to settle with them privately. So that's why they say come to terms quickly with your accuser while you're going with him to court before you get there. Because then you're gonna lose. Because if you get there, your ass is gonna lose. Mike, you shouldn't be cussing while reading the Bible. Okay, y'all get it. Y'all get the point. Come to terms quickly. Okay, let's see. While going with him to court, let the accuser hand you over to the judge. The judge to the guard, and you be put into prison. Reconcile quickly while you're on your way to court. Otherwise, they hand you over to the judge. You get the idea? As a matter of fact, there's another one say, come to a settlement. Let's see, reach a settlement. Here it is. Christian Standard Bible right here. Reach a settlement quickly. That's how you settle out of court right there. With your adversary while you're on the way with him to the court. See? So this is what they're doing. So when they send you something in the mail, you're supposed to actually, oh, here we go. Here's another one right here. Be allied with your plaintiff. You're the defendant now. Be allied with your plaintiff. I mean, come to peace with them. Come to some kind of reconciliation about what it is that they said about you. Say while you are with him in the street. It's before you get to court. Lest the plaintiff delivers you to the judge, and the judge delivers you to the tax collector. And you fall into prison. So all these different versions of the Bible, they basically teach you. See, the King James Version don't do it no justice because we don't speak that type of language like that. So, but that's why I use Bible Hub, because it shows all these different versions of the Bible and explains in detail what the scriptures are saying. But anyway, so this is what it is. When somebody have evidence against you, they're going to go, it's like they're going with the presumption, back to the word presumption. They're going with the presumption that you actually agree with them. I mean, that you agree with what you were accused of, because you never showed any proof that you did. You didn't respond to it. You have never filed any type of evidence into your court case. You didn't respond to them in private with no proof of what you're saying. You know what I'm saying? Like, for instance, there's a friend of mine. She was actually accused of, like some type of credit card debt or whatever. Thousands of dollars of credit card debt, some third party debt collector, whatever. But I'm like, they have no proof of their claim. Where's their proof? Where's the original contract? And she didn't know how to respond to it. And I know this stuff a lot better than she did. So she told me about it, and I told them to send me a picture of that document that they sent you, that they served you. And I responded to it. I responded to these people for her. And I emailed it to her, say, go ahead and get that thing notarized, make you a copy of it, send it to them. And she ain't heard from their asses since, and that was years ago. The bottom line is because they realize they don't have any claim, they're going with a presumption. Okay, they were flowing with a presumption, and they know that they didn't actually give her any money out of their own pocket. They suffered no loss at all. What they did was use her information, and they loaned her her money from her own minor account. You feel me? And they was expecting her to whatever, to basically they wanted to double dip, and they couldn't prove it with no original contract. So they went away because they didn't have any evidence. So the presumption was rebutted. So that's pretty much what happened. So they went away. As a matter of fact, that happened. Shit, that was years ago. I want to say it was maybe five or 6 years ago, and then I think maybe about 2 years later. It's about 2 years ago. It was 2 years ago. It was about 5 years ago when I did originally made responded to them, and then about I think a couple years later, she was like, they tried to make another attempt. Here it was like years later. And then I responded with the exact same thing, and they went away again. So they realized they have no win. You know, so that's been about 2 years ago since I did it the second time. So it was like 5 years ago when I did it the first time. I guess they went away for about 3-4 years. Decided I'm gonna try this again, and they just they went away. They won't bother. So anyway, but I added a little more sauce to the second response. But anyway, here we go. Let's see. Presumption as the deliverer of letters from mailing other than the post office or a street letter. Okay, I'm gonna get on back on the topic. But bottom line is, it's about rebutting presumptions of law. You have to rebut those presumptions. Okay, presumptions are either a law or of fact. They are either of law or of fact. Presumptions of law are conclusions. And inferences, more like conclusions, inferences which the law draws from given facts. Presumptions of fact shall be exclusively questions for the jury to be decided by the ordinary test of human experience. Okay, let me see something I wanted to pull from that, but I forgot what it was. But anyway, let me see. Producing evidence. That goes back to what I was saying. Here we go. If a party has evidence in such party's power and within such party's reach, by which he or she may repel a claim or charge against him or her, but omits to produce it, or if such party has more certain and satisfactory evidence in his or her power, but relies on that which is of a weaker and inferior nature, the presumption arises. A presumption arises that the charge or claim against such party is well founded. So, see, you chose it, not you just want to go along some other bullshit, and you didn't want to actually present the act, but this presumption may be rebutted. But you relied on that which is of weaker and inferior nature. So, and then say, because of that, a presumption arises that the charge against such party is well founded. So, since you relied on something weaker and inferior nature instead of actually proving with some satisfactory evidence, like right here, to rebut the claim, you omit to produce it. Then they're going. That's what causes the presumption to actually be well founded. That's how they come up with the presumption, because you failed to produce anything to prove your innocence or to prove your case. But this presumption may be rebutted. You got to rebut it. You can still rebut it. So if you fail to do it, that's how they came up with the presumption. It's because you failed to produce the evidence. Now, in order for an equitable estoppel to arise, there shall generally be some intended deception in the conduct or declaration of the party to be estopped, or such gross negligence as to amount to conclusive fraud or constructive fraud. Sorry about that. Constructive fraud by which another has been misled to his or her injury. That's not what I was trying to look for when I saved this damn screen. I was looking for something else. But let me see if I can find what I was looking for. That's why I was pausing so damn much just then. Let me see if I can find it. That probably was it where I was at already. That's what I was reading, I believe. Defined. Let me see. I might just wrap it on up right here, but we're gonna see. A conclusive presumption of law are termed estoppels. Affirmative. Okay, I ain't gonna go there. It's kind of related, but I don't want to go there right now. I'm probably go there in another video. But bottom line is you have to rebut these presumptions, y'all. If you don't rebut the presumptions, you can't get anything to shut down. You can't shut anything down without rebutting those presumptions. They're gonna flow, and then you wonder why you're getting railroaded because you chose not to provide evidence to rebut the presumption. I mean, I did show y'all, and I showed y'all enough meat and potatoes concerning this topic, then to keep going back and forth in these different things to read what these laws are saying. This is here in Georgia, as y'all see, it's in Georgia, but I'm sure you have the same rules applying in your state too, but you need to look in your state so you can see for yourself. I showed you what it says in Georgia, and these rules apply all across the world, all across the country pretty much. So you need to, just look in there and see. Read it for yourself. All right, y'all, I'm gonna get on out of here. If you haven't liked and subscribed yet, please take this time to do so. Hopefully this was helpful to y'all to help motivate you guys to understand the importance of evidence and presenting your evidence to prove your case. It's different things to prove. There's different presumptions. It's a lot of presumptions that they have in the courts. But if you don't present the evidence to rebut these presumptions, then that's one of the reasons we're getting railroaded in court. So got to be willing to do that. All right, y'all. I'm gonna get on out of here, y'all. M. Rose signing out.